I do want to thank the people who've been sending me videos to check out. There are thousands and thousands of these videos out there, and some of them are many hours long, and I just don't have the time to check them all out myself. So I appreciate people sending me ones that have good legal questions to answer. This one is by James Freeman. It's the Waxahachie High School video. We're going to take a look at it to see where James's First Amendment analysis goes awry. I do want to say, though, that I support James Freeman. He's out there, he's advocating for your First Amendment rights and my First Amendment rights. He's trying to expand them. That is, I think, a noble goal. It'd be great to have expanded First Amendment rights. However, I always am of the impression that it's better to know what the law is that you're trying to change before you go around advocating changes to that law. So here we go. Oh, this is going to be 2 times speed. It'll be linked below. Please go give James Freeman a view, give him a like, give him a thumbs up, whatever.
What are we doing out here today, sir? Picking up signs in our name. What area? Where is that little?
Free speech areas. The school has placed a 10 by 10 free speech area. I'm not a fan of free speech zones, but they appear to be valid time, place, or manner restrictions. And as of yet, the courts haven't said that they're not valid. So,
Little box over there? That's been approved by the school board? Yes. So you work for the school board? Is this public property here? How about right here? Is this public?
Public property has never been an element of a First Amendment test to see whether or not the First Amendment applies or is being violated by a specific statute or ordinance or regulation. So asking someone if it's public property, it's meaningless. You're just wasting your time and breath.
Public property right here? For certain things, it's either a yes or a no. Is it public property right here or no?
It's public property.
Okay.
The school board has
So
the ability to make designations for certain things, and that's what they've done in this case.
Are you sure about that?
Pretty sure about
Are you sure that they're allowed to make rules and regulations that violate the Constitution of the United States?
This guy hasn't said that they're allowed to make rules and regulations that violate the Constitution of the United States. He said they're allowed to make rules and regulations that deal with speech on their property. And he's correct.
States?
Depends on which part of it.
Sorry, I didn't hear you with the bike going by. What was that?
I said they have the ability to do that for the electioneering. There's a clause in there that they can set guidelines for when these things are supposed to be.
Okay.
Now,
So they could set guidelines for how people conduct First Amendment activities on their property.
whether you feel that that's reasonable or not, then you get a judge or somebody to tell us that it's not reasonable, and then we will.
So to be specific.
And this guy is correct. If you don't think it's reasonable, you get a judge to tell the school board that it's a violation of the Constitution. Arguing with a security guard is not going to change anything.
You did say that the school board does have the authority to supersede the Constitution of the United States. Is that right?
It's not what I said.
Well, you have the ability to supersede the Constitution, or I mean, the Constitution wouldn't allow you to do this, right? We all know that. I mean, any 6-year-old at one of your elementary schools could explain to you that this is wrong, right? What?
If you're getting your legal advice from a 6-year-old, or if your level of understanding of the First Amendment is equivalent to that of a 6-year-old, then I would posit to you that your level of understanding is too low, and perhaps you should seek legal advice from a more competent counselor than a 6-year-old.
What's your name?
E-R-I-K-K-Y-O.
Eric Kylan. Are you an actual officer, or are you okay, hired goon? Is there any other security officers for the district? Okay. Did you, by any chance, have to swear an oath to the Constitution to be a security officer for the district? No. Okay. That's good, right? Because you'd probably be in extreme violation of your oath at this point if you had. Do you love America? Do you love the Constitution? Do you think that maybe you should go put those signs back in? No. So you're a hypocrite.
No.
Do you love America? Do you love the Constitution? Then maybe you should put those signs back. No? Then you're a hypocrite. Well, here's my interpretation of that, James. Do you love America? Do you love the Constitution? Then shouldn't you understand the document that you claim to love? Because you don't. This is Hazelwood School District v. Kuhlmeyer. This is a United States Supreme Court decision. You may have heard of the United States Supreme Court. They're pretty popular around here. They draw big crowds. Anyway, so what they held is that public schools do not possess all the attributes of streets, parks, and other traditional public forums that, time out of mind, have been used for the purposes of assembly, communicating thoughts between citizens, and discussing public questions. So they just said there that the public school, is not a traditional public forum. And because, James, because you are so versed in the First Amendment and what it means and how to analyze it, you will know that lowers the threshold that the government has to meet from moderate scrutiny down to a rational basis review. You knew that, right? Right, James? Because you love the First Amendment, you love the Constitution. Hence, school facilities may be deemed to be public forums only if school authorities have, by policy or by practice, opened those facilities for indiscriminate use by the general public. So, James, are you contending that the school has opened its facilities for indiscriminate use by the general public when you're claiming that it's public property? Are you saying that they've opened their facilities for indiscriminate use by the general public? Because that is the test that you, I am sure, were well aware of when you launched into it on this poor security guard, right? Or by some segment of the public, such as student organizations. If the facilities have instead been reserved for other intended purposes, communicative or otherwise, then no public forum has been created, and school officials may impose reasonable restrictions. That's the rational basis review, is reasonable restrictions on the speech of students, teachers, and other members of the school community. The government does not create a public forum by inaction or by permitting limited discourse, but only by intentionally opening a non-traditional public forum for public discourse. Are you contending, James, that they have opened the school up for public discourse? Or maybe, just maybe, they use that free speech zone to open up a small section for a limited time for public discourse. Maybe, huh? So, I believe that James's understanding of the First Amendment was on par with a 6-year-old, and perhaps he should up his game. This, however, is a very interesting case. The whole reason behind the Waxahachie, why they have those signs up, is because there's an election going on, and the school they're going to have voting on school property, and so they put that 10 by 10 free speech zone for people to put their political signs and whatnot in there, with restrictions. But this is an interesting case out of Minnesota. It's Minnesota's Voter Alliance v. Mansky. It's been argued in front of the Supreme Court. We're just waiting for the decision to come down. But in it, there's a statute in Minnesota that prohibits people from wearing political apparel on or at or around polling places on primary and election days. And this guy, Andrew Selick, he was wearing a Tea Party t-shirt and a button that advocated for photo ID to vote. And the district court dismissed all the claims and everything like that. However, it's an interesting case to see how the Supreme Court is going to rule on free speech, political speech at the polls. And that'll be interesting because there are a lot of places like California, they have a buffer zone around polling places. So you can't like harass people coming in to vote, wave signs in their face, say, hey, vote for this person or vote for this statute or whatever. So they have buffer zones in California. So it'll be interesting to see what the Supreme Court does with Minnesota Voters Alliance v. Mansky. It may change some of the analysis. And because you love the Constitution and because you love the First Amendment, I'm sure you'll be right on top of it to see how it changes the political landscape. Anyway, thanks for watching. Happy auditing and have a great Saturday.